Ma'am, shall we start, ma'am?
Yes, please.
Please.
Thank you, ma'am. To start with, I request all the participants to keep your mic in mute and video on for the smooth running of the inaugural session. Dear participants, please switch on your video for the inaugural session. The road to success is not an easy path to walk. It is filled with thorns, pitfalls, even at times it may lead to death. Only those with strong determination in life could go for the fruits of the success. We can come across people in the history, all those successful people had a failure in their book history, but they never gave till they become successful. Winners do not do different things, but rather they do things differently. They take extra energy to walk extra miles till they reach their goals. Honorable Vice Chancellor of Tamil Nadu National Law University, respected registrar, respected dignitaries, galaxy of intellectuals, invited guests, faculty members, and my dear participants from various institutions across the country, a very good morning to one and all present here. I am Nirmal Singh Hira, Assistant Professor, Tamil Nadu National Law University, Tiruchirappalli. It is a matter of immense pride to be here before you all this morning. On behalf of TNNLU Tiruchirappalli, I am delighted to offer a gracious welcome to all of you this inaugural session on the one-week faculty development program on teaching methodology and pedagogy and interdisciplinary approach, a virtual program organized by the Faculty Improvement Program Committee, Tamil Nadu National Law University, Tiruchirappalli. Dear participants and respected dignitaries, may I request you all to please rise for the Tamil Thai Valthu. Thank you all. The title of the FDP is Teaching Methodology and Pedagogy and International Approach. Faculty Development Program will not only promote the practices relevant to technical education, but also motivates the faculty to achieve competitive teaching and learning environment, thus channelizing development with respect to academic qualification and personal matters. The FDP has been considered as a standalone educational pedagogy in fostering knowledge and professional skills of faculty. With this small introduction, now I call upon Dr. S. Amirthalingam, Associate Professor of Tamil Nadu National Law University, to welcome the gathering. Over to you, sir.
Thank you, Mr. Nirmal, sir. A very good morning to one and all joined virtually. So thank you everyone for joining in the early morning for the inaugural session. I am Dr. Amirthalingam, Associate Professor of Law and Convener of the Faculty Improvement Committee of TNNLU. தொட்டனை தூறு மணற்கேணி மாந்தர்க்கு கற்றனை தூறும் அறிவு மணலில் உள்ள கேணியில் தோண்டி அளவிற்கு நீர் ஊறும் அதுபோல கற்ற கல்வியின் அளவிற்கே அறிவு ஊறும். The couplet goes, water will flow from well in sand in proportion to the depth in which it's stuck, and knowledge will flow from a main proportion to his learning. It is honor and privilege for me to before you to welcome this August gathering for the first ever 1 week faculty improvement program committee's event on faculty development program in the interdisciplinary approach. On this occasion, I wholeheartedly welcome our Honorable Vice Chancellor Ma'am, Professor Dr. V.S. Elizabeth, who is the main pillar of the institution. Without Ma'am's constant support and encouragement, this event is impossible. Madam also has initiated several steps to bring this National Law University on par with other NLUs in India. And Ma'am's also strived last 1 year to compete with the NAC accreditation process for the first time in its inception. Thank you, ma'am, for being part of this faculty development program on interdisciplinary approach, ma'am. And ma'am also had consented to deliver a talk on need for interdisciplinary approach to teach study law with their busy schedule. So ma'am had taken several initiatives, including assisting the faculty improvement committee to arranging all the resource persons. Thank you very much, ma'am. We wholeheartedly thank you and welcome for this FDP, ma'am. At this juncture, it is my great privilege to extend my warm welcome to our respected registrar, ma'am, Miss K.R. Leela, registrar of TNNLU and senior civil judge, who is always kind and supportive in every set of the event which TNNLU is organizing. With respect to specific mention of FTP, though it was a holiday and Sunday, so even late hours we disturb our ma'am. So without any hesitations, ma'am had extended support. So on behalf of the Faculty Improvement Committee and on my own behalf, I welcome ma'am. It is also my duty to welcome our finance officer, Tirumadi C. Anuja ma'am, for every support, including creating a bank account and QR code. Since it's the first event, so we thought of to create, so ma'am had extended her support without any hesitation. Although ma'am had engaged with some other administrative task. Therefore, on behalf of the Faculty Improvement Committee and on my own behalf, I welcome ma'am. It is my great privilege to welcome all the participants from various institutions across the country who are the real and great supporter of this event. I express my heartiest welcome to all the participants, including my colleagues. I welcome sirs and ma'am. I extend my welcome all the administrative and technical staff from Deputy Registrar of TNNLU, all the Assistant Registrar of Finance, Administration, Purchase, and Section Officer, Mr. Tamilmani sir, Mr. Suraj sir, and all the junior assistant, other technical staff, with a special thanks to our IT section. So without whose support and constant involvement in the process of creating all, this particular event would have been impossible. So therefore, on behalf of the Faculty Improvement Committee and on my own behalf, I welcome each and every one of you.
Thank you,
Franklin
sir.
has said once, tell me, I will forget. Show me, I may remember. Involve me, I will learn. So therefore, I request all our learned participants from learn with your involvement. So with this, I welcome each and every one of you. Thank you.
Thank you, sir, for your warmest welcome. I realize by being a teacher, I am making an important contribution to all the national development initiative. With this quote, now I invite Dr. Thomas Felix, Assistant Professor of Economics, Tamil Nadu National Law University, Tiruchirappalli, to give a formal introduction about the Faculty Improvement Committee and the Faculty Development Program. Over to you, sir.
Thank you, sir. Respected Vice Chancellor, Professor Dr. V.S. Elizabeth, respected Registrar Ms. K.R. Leela, respected FO Madam, respected AC members, EC members, GC members, faculties of TNNLU, dear participants, admin staffs, and IT staffs. Once again, I would like to welcome you all to the 1-week faculty development program on teaching methodology and pedagogy, an interdisciplinary approach to be held from 17 to 21 January 2022. Myself, Dr. K. Thomas Felix, Assistant Professor of Economics. I would like to take this opportunity to share about the Faculty Improvement Program Committee. The FIP committee is a brainchild of Professor Dr. V.S. Elizab, Vice Chancellor, TNNLU. It has been set up in order to cater the needs of the academicians to keep them updated with the research and teaching methodologies, besides the developments in their respective disciplines. The Faculty Improvement Program intends to facilitate upgradation of knowledge, skills, pedagogy, educational technology, motivation, communication skill, management, and other relevant aspects to keep pace with the changing scenario in the legal education. The FIP is also designed to make members of the teaching fraternity aware of the technological development in pedagogy, modern teaching technique, tools, and methodologies using an interdisciplinary approach. So this is our first ever event under this FIP committee. So thanks for your unconditional support for this event. Once again, I would like to thank you all for participating in this event. Thank you.
Thank you, sir. Invest in your professional development, specialize, and team up with the colleagues who have different strengths. One quality of leaders and high achievers in every area seems to be a commitment to ongoing personal and professional development. Dear participants, I am happy to invite our esteemed and erudite Professor Dr. V.S. Elizab, Honorable Vice Chancellor of Tamil Nadu National Law University, Tiruchirappalli, who is known for strong, courage, and successful in life, to give the talk on the theme Need for Interdisciplinary Approach to Teaching and Study of Law. A small introduction about Professor Dr. V.S. Elizab. Professor Dr. V.S. Elizab is the fourth Vice Chancellor of Tamil Nadu National Law University. She worked as professor teaching history and feminist legal theory at the National Law School of India University, Bangalore before this. She began her career humbly as a part-time lecturer in history in a pre-university college in Bangalore, soon after completing MA in history, securing the second rank from the Bangalore University in 1984. Till 1987, Madam taught in the Indiranagar Junior College, NMKRB College for Women, and lastly as a full-time lecturer in history at the Maharani Lakshmi Ammani College for Women from 1986 to 1987. In 1986, Madam passed the University Grant Commission Juniors Research Fellowship exam, which took her to the Department of History, Mangaluru University, to pursue the PhD program there. Madam has joined the National School of India University as a research associate on 9th September 1991. She was the first faculty with a master's degree in history to join the faculty of NLSIU to teach history in what was then an experiment in legal education in India, set up by the Bar and Bench of India. She had the responsibility to design 3 courses for teaching history to law students. The curriculum that Madam has developed since then has been drawn upon by the Bar Council of India in designing the prescribed syllabus for teaching history in the 5 years BA LLB program, and also by faculty who teach the history to law students in the various law colleges and law universities. Madam also taught women and law related courses as an optional courses for students at the NLSIU. Based on her work as the coordinator of the Center for Women and Law, NLSIU, the research work done for the International Center for Research on Women, USA, and the courses on women and law that she taught at NLS, she was invited by the National Commission for Women in 2003 to 2004 to be part of the team set up to plan and design the curriculum for teaching feminist jurisprudence in the law college and law universities of the country. At the same time, the Washington College of Law, American University brought together faculty from 6 different institutions, teachers of women and law, to build a team to teach law from the feminist perspective. The project, Gender and Legal Education, provided the forum, the Gender and Law Association, for faculty teaching feminist jurisprudence in the various institutions to spare their experience, the curriculum, readings list, and the teaching methods. This led to her teaching feminist jurisprudence to both undergraduate and graduate students at NLSIU since then. In 2005, Madam was invited to join a group of law teachers from various parts of the world to found the International Association of Law Schools. She was one of the founding members of the governing board of the IALS 2005 to 2009 and 2010 to 2013. In 2012 to 2013, she was appointed as a member of the history level committee on the status of women by the government of India. She loves teaching history and teaching young people. Feminist is a way of life for her. Feminist legal theory is her latest research project. Most of her publications are on themes related to law and violence against women. She is passionate about her students about history and women's right to live with dignity. With this brief introduction, now I call upon Professor Dr. V.S. Elizabeth to deliver the talk. Over to you, ma'am.
Thank you, Mr. Hira, for that very kind introduction. You're probably one of the few people who's actually introduced me in the right way, I would say. Thanks to Dr. Amarthalingam and the Faculty Improvement Program Committee for having invited me to deliver this inaugural address on the need for an interdisciplinary approach to the study and teaching of law. Respected members of the Faculty Improvement Program, dear colleagues from TNNLU and from other institutions, colleges, and universities, it is indeed an interesting opportunity for me to share with you my perspective on the need for teaching law, studying law from an interdisciplinary approach. Now, this is something, of course, a product of my 28 to 30 years of teaching in the National Law School of India University and heading this very young law university, the Tamil Nadu National Law University. So it is this 30 years of teaching law students, working with faculty who teach law and other courses that I have drawn upon in order to enable me to administer this university, and also which has convinced me of the need to ensure that all the law universities where we give a composite degree, that we should be integrating this interdisciplinary approach into all that we do in the law university, be it teaching, be it the research work we do, be it the learning of law that we do in these universities. It is extremely important that we approach it from an interdisciplinary perspective. So as you know, the vision of the Tamil Nadu National Law University is to impart quality legal education nurtured within a robust culture of interdisciplinary research and teaching in an equitable, respectful, and supportive environment, producing legal practitioners and scholars who will be committed to justice, social transformation, and national development. Because I believe that without looking at the law from an interdisciplinary perspective, we will not be able to produce graduates who will be committed to social transformation and national development. They may be committed to justice, but may not bring about social justice and social transformation without this interdisciplinary understanding of law. That's the reason why the mission of the Tamil Nadu National Law University, while it is to achieve global recognition as an institution of eminence and excellence in all spheres of legal education, the objective is to achieve that goal by being rooted in an interdisciplinary approach to the study of law. Because only then can we produce graduates who will be independent critical thinkers. Otherwise, they're just going to follow the herd and they're just going to be blind supporters of the law without looking at the problems and the limitations of the law. And also, I believe that when we teach and we do research from an interdisciplinary perspective, we will produce socially responsible human beings. It is with that objective that all the activities of the Tamil Nadu National Law University are done from an interdisciplinary perspective. Be it the teaching of law or the research we conduct, the programs we organize, everything is informed by an interdisciplinary perspective. And that's the reason that this first ever faculty development program being organized by the Tamil Nadu National Law University consists of speakers from various walks of life, teaching different disciplines in the different law universities and outside of it. Because we believe that through this approach, we can ensure and also deeply root this objective of ensuring that the teaching, the research and study of law is done from an interdisciplinary perspective. So while I will be delivering this introductory talk, if you look at all the galaxy of speakers that we have identified, they are from different disciplines. Professor Dr. Thomas Matthew from the Gujarat National Law University teaches science at the Gujarat National Law University, while Professor Dr. Senthil Nathan is responsible for the development of the use of technology in teaching at the Bharathidasan University. Professor Dr. Sitaram Kakarala, who taught at the National Law School of India University Political Science and later Human Rights, and currently is a professor at Azim Premji University, will bring to us the interconnections and the interaction needed between law and political science. We have Mr. Satyaranjan Mishra, who is an assistant professor of commerce, who will bring to us a deeper understanding of the close connection that there is between the teaching of business laws and the disciplines of commerce and accountancy. On the other hand, we have Dr. Nityananda from the Indian Institute of Management, Trichy, who is also a product of the National Law School of India University, as he got his PhD in intellectual property rights law from NLSIU, will bring to us an understanding of the relationship between law and the management courses. Then we have Dr. K. Parameshwaran, who essentially is a constitutional law teacher, but deeply involved in the learning of spirituality and practicing spirituality, who looks at the need for this integration of law and spirituality in order to instill a strong sense of justice and moral values. And through his talk, you'll be able to see the connection between the two. Then, of course, we have our own Professor Dr. Ebenezer Joseph, who has a long career of teaching law in different institutions, and the last of which was at the Tamil Nadu Dr. Ambedkar Law University, and currently visiting professor at TNNLU, who will introduce to us the concept of the rule of law in administrative jurisprudence. We have Professor Dr. Prashanshu, Professor of English at the National University, Delhi. We have very few law universities where we have English being taught in the law university, and National University Delhi, TNNLU, GNLU are a few examples of the universities where this is done. So here we're taking it to the next level to see the connections between law and literature. Oftentimes we use Shakespeare, we cite various literature even of our own country, be it the Smritis or the Tirukural in Tamil Nadu. We at the same time do not see how closely connected are the two disciplines, and that will be successfully done by Professor Dr. Prashanshu. Then we have, of course, Professor Dr. Anita Nagar, who teaches economics and who has spearheaded the law and economics movement in India, along with other colleagues who teach economics in the various law universities, and as well as with the practicing lawyers. Then, of course, we have two vice chancellors, Professor Dr. V. Vijay Kumar, one of the founding faculty of the National Law School of India University, who taught political science and constitutional in the early years, but since then who has largely only been teaching constitutional law and international refugee law, who will bring to us the methods of teaching that were introduced at NLSIU, which made the NLSIU experiment a success. And therefore, why today we have 24 or more national law school type institutions all over the country. Then, of course, we have probably the youngest of all the vice chancellors, Professor Dr. Sudhir Krishnaswamy, a former student of mine, an alumnus of the National Law School of India University, currently, of course, vice chancellor there, who is so completely connected with the modern tools of technology, and that he will bring to us in order to enable us to see how much there is change in the pedagogical practices of teaching law and the need to use these modern ICT tools. Then I have two other good friends of mine and good scholars of law. We have very few legal scholars in this country, and amongst them we can count Professor Dr. Amita Dhanda, who is a professor of law emeritus at the Nalsar University of Law in Hyderabad, and she will focus on the suitable tools we need for evaluation, since we do this teaching of the BA LLB, BCom LLB, as well as, of course, BSW, BSc, and a whole variety of other such combinations, producing composite degrees in law. Then we have Professor Dr. Ved Kumari, the current Vice Chancellor of the National Law University in Odisha, who otherwise is a faculty from the Delhi University, and who will speak on the role of effective teaching skills for attaining excellence in higher education institutions. So when you look at this galaxy of scholars and teachers that we have put together, you can understand where we come from. the importance of ensuring that we have an interdisciplinary approach to the teaching, the doing of research, and the study of law. Now, the question that will arise in our minds is, why do we need to do that? Isn't law rich enough on its own? Is it not the discipline that deals with society, responsible for the regulation and organization of society to ensure a very businesslike and organized way of functioning of society? Why do we need to look at law from the perspectives of other disciplines? Why do we need to use the tools for the study of society, economy, politics, etc., in the pursuit of the study of law? The answer is simple and straightforward. The issues and problems that a law graduate, be it a practicing lawyer or a judicial officer, has to confront are problems that are created by the society we live in. And the society we live in is continuously evolving. I mean, I'm 60 years old now. In these 60 years, I have seen how drastically society has changed. From a time period as late as, the 2000, when, we did not use computers, we did not use, Android phones to teach. We needed a blackboard and, chalk in order to make our points clear. We have come to the situation where we're conducting classes online. And we're using all the technology that is available in the online media in order to teach. And those who are best acquainted with this new technology are the ones who are doing this most effectively. Now, when you look at the kind of tools that are available to teach, they are mind-boggling. And for somebody from my generation who is not adept at the use of technology, it even is so difficult to find my way through it and use this technology effectively. That is one part of it, the fantastic pace at which technology has been developing and evolving. On the other hand, is the very changes in our society. Right? I mean, from using hard cash, right, where your money was worth the value that it carried, to a point in time where now we're talking about imaginary currency, right? Cryptocurrency, bitcoins, everything to be done online. The government doesn't want us to withdraw cash. It doesn't want us to deposit cash. It wants us to, completely carry out all our financial transactions online. And as one of my younger colleagues who is here, Mr. Gino Kurian, who wants to pursue research in this, right, to look at how does a law that was enacted, in the 19th century, the late 19th century, how effective can it be in addressing the problems of the way in which we do business today, almost entirely online? How does one comprehend something like that without understanding the way in which our economy has changed in this last just 20 years? Forget about the 75 years since independence. On the other hand, there are some problems which seem to be perpetual, eternal problems. The problems of women's subordination and exploitation, the problems of caste conflict, the problems of caste subordination, the problems of exploitation based upon caste. Then, of course, there are the issues of sex and sexuality. There are the problems of communalism. There are the eternal problems of class conflict. We are living in the 21st century. We are talking about kind of technology that can take us into outer space, possibly colonize new planets. But what is the point of it all if we have not ended inequality on Earth? Are we going to carry this inequality into these new planets which we want to colonize? And how do you understand the solution to these problems if you don't understand when and why those problems came into existence, those institutions which perpetuate these problems came into existence? So if you don't have a good grasp of the study of the past, if you don't have a good understanding of the sociological institutions of which all of us are products and all of us are victims, how are we going to use the law in order to solve these problems. And unless we transform the society through the law and through changes in the social, economic, and political spheres, how do we expect to ensure we achieve the objective of justice in our society? It is this failure to comprehend the close connection between law and the society which produces it that has resulted in mere lip service to the cause of justice. So we have formal equality, and presumably all the institutions of law and justice are producing justice. But we know that access to justice itself is imaginary. Vast majorities of the population in this independent democratic republic are yet to access justice. On a daily basis, you read about the injustices perpetuated, not just by the external forces in society, but the very institutions that are supposed to safeguard and produce justice. It is in order to understand these issues that I believe that law has to be studied, taught, and researched into from an interdisciplinary perspective. And in our country, legal scholarship is still very young. Though the legal profession might be old, the legal profession as it deals with the current legal system is very young. In fact, we are the products of the colonial period, and we cannot wish it away. We can't pretend it didn't exist. 200 years of colonial rule has transformed every institution in this region, leave alone India. And unless we recognize that and we understand why did the East India Company, followed by the British government, created these institutions of law and justice, we will not be able to understand how do we transform them in order to produce the justice that a democratic republic, free India requires. It is a continuation of these colonial institutions that is largely responsible for the continuation of a colonial mindset, be it the judicial system, the judicial institutions. You know, the very fact that you've got to address judges as lordships, the very fact that you've got to defer to them and treat them like they are different from us. You will not see that if you were to travel anywhere in Europe or in America. Judges are just ordinary human beings. You and I, we teach in a university and they're administering justice. That is all there is to it. But the way we treat them, all that paraphernalia, all that protocol is a product of the colonial administration of justice. Take up bureaucrats. They're supposed to be serving the government, which is supposed to be for the people, of the people, by the people. And yet it is the bureaucrats and the law enforcement agencies that all of us fear. Instead of looking to them for help and support, we actually fear them because of the way in which they are continuing with the mindset of the colonial administrative structure. So colleagues, unless we look at this close connection between law, the society, the economy, the polity, the past that has produced it, we cannot really use law in order to bring about social transformation. Now, some of us, of course, may not want to bring about social transformation. We are happy with the caste system. We are happy with patriarchy. We are happy with the inequalities of the class system. But even then, in order to even preserve that status quo, it becomes important to understand how can you preserve that status quo? And in order to do that, you need to understand the society which produces these laws and the legal systems that are responsible for the administration of law and justice. As someone who has taught history for well over 37 years, and as someone who has been teaching feminist legal theory for more than 15 years, I can tell you how using the perspective of the understanding of the past and feminism has enriched my teaching of law as well as history in the law universities that I have been connected with. I have taught not only at NLSIU and TNNLU, I have taught at NALSA, and I have also had close relationship with the National Law University, Delhi. And through all of them, when I have used these perspectives, it has enabled me to transform, first of all, the discipline that I belong to and I teach largely. But it has also given me a much deeper understanding of law and justice. And through that process, I believe that I have been able to transform the way in which my students are able to look at the law. If you have to look at the testimonials that the products of the National Law School of India University have to give, it will make it abundantly clear how the study of these disciplines has enabled them to look at society from a much broader perspective than the way in which most others who study the law have looked at it. Apart from all this is the very problems that come before our courts, right? From trying to resolve issues dealing with the past, to issues relating to a woman's reproductive system, to the issues of caste. All of these are issues that come before any judge today. Issues relating to technology, to intellectual property rights, to rights of the trans persons, all of these come before the judicial officers. And when we look at these judgments, the decisions that have been made in the last 70 odd years since the Supreme Court came into existence, we talk about landmark judgments. We identify judgments that we consider to be important, judgments that we consider to be path-breaking, judgments that have transformed the way in which our society functions. And in many cases, judgments which have brought about social transformation itself. At the same time, we have numerous judgments, far more than these good judgments, which have been errors of, decisions, errors of judgment, and which have perpetuated long-standing social problems besides creating new ones. And all of this comes from the failure on the part of our judicial officers to have an interdisciplinary approach to the administration of justice. Failure on their part to accept the limitations they have as law officers. It is when they have had a good amicus curiae who has been appointed, who has a deep understanding of these issues, that they have been better informed, and therefore the decision-making has been transformative. I can think of the Vishaka judgment as an example of a good judgment. I can think of the judgment from the High Court of Andhra Pradesh, the Sarika case, the Sarita case, where Justice Chowdhury delivered one of the most sensitive judgments. He was not a feminist, consciously, but because of his sensitivity to social issues, his understanding of gender issues, he was able to deliver a judgment which brought to light the way in which law would impact on a woman's life. And then you have the judgments relating to the Ram Janmabhoomi, etc., which are also problematic. Now, if you want to ensure that our judicial officers, our lawyers, will function from a better understanding of society and therefore will interpret the law through the use of the techniques, the research methods that are available in other disciplines, only then can we ensure that as we go forward, the products of the institutions where we are teaching will go on to deliver social justice, will contribute to the transformation of our society. And at the same time, that they will become critical individual thinkers and not blindly follow everyone who comes and speaks very well, whether it's in the political forum or in a court of law. Now, having given you this broad introduction to why we should be looking at law from an interdisciplinary perspective, let me just take a few more minutes to delve into the two disciplines that I have been associated with and been teaching for the last several years. Firstly, history. When I started off my career of teaching history at the National Law School of India University, by then I had been teaching history for 7 years before that. I had spent, a great part of my life just studying and teaching history. So for me, coming into the law school and, trying to adapt the teaching of law to law students was extremely problematic. Because I believe that the discipline that I came from was so rich and so old that it would be greatly limiting if I were to merely teach, the various laws, the Charter Acts, the judicial reforms, the Indian Councils Act. And that is what I was compelled to teach for the first 2 years of teaching at the National Law School of India University. Because it was the law teachers who had designed those courses, law teachers who did not have a grounding in history and who did not have an understanding of what is legal history actually. To them, the purpose of history, economics, political science, and sociology in the law school was to provide a context, a background for the study of law. So history they wanted to be taught so that the students understand the constitutional history, all these councils acts, which culminated in the adoption of the Constitution of India. They wanted political science to be taught so that students will understand concepts like the state, legislature, power, etc. And so on and so forth with the other disciplines as well. So they never ever thought of this as an interdisciplinary thing. Like, how do you teach constitutional law looking at the past? Instead, they thought this is a task that should be done by the faculty who teaches history. So the first 2 years, the three courses that I was asked to teach, one was legislative and administrative history of India. The other was judicial history of India. And the third one was the history of English and Roman law. I struggled with them because, trying to teach judicial reforms, Warren Hastings did this and then he changed it in 1776 and then he brought it back in 1778. And then, of course, Cornwallis came and then he did away with all of that, he invented something else new. It just seemed like absolutely unnecessary, because how did any of those things impact the way in which we practice law today? Whereas some of the things that Warren Hastings did are extremely important. The Gentoo Code, for example. It is through that the very idea of personal laws was introduced into the Indian subcontinent. It isn't so much the judicial reforms he carried out, in terms of, whether he was following the Adalat system and, whether he was bringing in other changes there. It is more to do with these kind of things that you needed to focus upon. And also, how did the principles of justice and equity come into the East India Company's administration of justice in the Bengal presidency? But the first 2 years, I was just trying to teach Warren Hastings' judicial reforms, Cornwallis's judicial reforms, and the Indian Councils Act, and of course, the Government of India Acts, etc. And they're all overlapping. How do you separate legislative, judicial, and administrative history from each other? They're all products of the same legislations and judicial reforms. And being a student of history, I felt that the students needed to understand why were these changes ushered in? And how did those changes take place? Why is it that the policies pursued by Bentinck were not continued, by Dalhousie or by Lord Ripon or by Curzon? Why did these policies change? And how did that impact the society, the economy, and polity of India? Because caste system did not disappear. Women's subordination did not disappear. If anything, these intensified. Why did they intensify? When you start asking those kind of questions, then the course that you construct becomes very different. It is that which resulted in me changing how I taught history and what I taught as history to law students at the National Law School from the, I joined in 91. So from 94, 95, I began to teach history differently. And one of the things that influenced what I taught at NLSIU was what had transformed my own thinking and my relationship with the discipline of history. Like most of you who studied history in school, in PUC, and maybe some of you even in the undergraduate courses, I also studied history largely from a nationalist perspective. the books by, R.C. Majumdar, R.K. Mukherjee, Nilakanta Shastri were the books that were used to teach me history in my undergraduate and my postgraduate days. I wasn't even introduced to the philosophy of history till I went for my PhD. As Mr. Hira introduced me and told you that I got the UGC JRF, that was one of the life-transforming things that happened to me, right? Because I got the JRF, I was able to leave Bangalore, leave the Bangalore University and go to the Department of History, Bangalore University. I wanted to go to JNU actually, because JNU then, and for a long time, till the last 5 years or so, JNU was the institution where the most recent writings in history, the most recent methodologies of doing research and teaching of history were practiced. It was JNU which had this internationally famous scholars in history. So unlike the discipline of law, where you have an Upendra Bakshi, who is an international legal scholar, that the discipline of history in India has international scholars, scholars of international repute. Professor Romila Thapar, Professor Bipin Chandra, Professor Ram Sharan Sharma, Professor D.N. Jha, Professor, Bipin Chandra, all of them who are, excepting D.N. Jha, they're all passed on, as well as, of course, Professor Romila Thapar. But it isn't even just them, right? It was the 6 months of my PhD program was spent in studying what is history, the philosophy of history, the methodology of history. And that made me fall in love with history. Reading What is History by E.H. Carr, C-A-R-R. He just blew apart all the assumptions about history that I had. I decided to teach history, to become a teacher of history, because history had been taught so badly to me from my school days till my post-graduation days. Only in my post-graduation days, I had the exception of Professor Srinivasa Murthy, but everybody else was uniformly bad. Just like, in the legal profession, where most people who took to the teaching of law joined, this profession of teaching of law because they failed at everything else. Similarly, with the teaching of history, people decided to do a master's in history and teach history because they had failed at everything else. And then, they continued to teach badly. But I had my father, who was merely, an intermediate pass, who taught history so interestingly, who made it alive, and who therefore made me realize that history could be taught well. History could be made interesting. So that is what started me off on the path of, deciding to do my master's in history and then, to become a lecturer in history. But the event, the time which made me fall in love with the discipline of history was when I went for my PhD and I studied E.H. Carr. And since it transformed, because it showed me how dynamic the discipline of history is, because people have these funny notions about history, right? One is that history is about the past, and therefore there is nothing new, nothing that can be changing that anybody who studies the past can deal with. So most people think history is so boring. It is so full of dates and, strange names that one has to by heart. And that is the reason for the aversion that a lot of young students develop towards the discipline of history. Because a lot of history that has been written by imperialist and nationalist scholars is political and military history, a little bit of administrative history, but barely anything on the social and economic history of the world. But when I read E.H. Carr, who exploded this myth about the objectivity in the discipline of history and demonstrated how history is not about the past, that history is really about the present, that it is an ongoing dialogue between the present and the past. That was absolutely stunning, exciting for me. And since then, I had never stopped loving history and teaching history with a passion. And that is why when I began to teach history based on the curriculum that I developed from 94-95, I introduced E.H. Carr, What is History, to the first year students. Students who had just completed their 12th standard and had come into the law school, were exposed to E.H. Carr's What is History? And the explosion of this myth of objectivity of anything. No discipline, no human being can be objective. No one is objective. All of us carry several baggages. Baggages of caste, gender, our social upbringing, the history, the culture, the religious values, all of these inform every decision we make. And when we pretend that these things do not inform our decision making, we are lying and we perpetuate those injustices, those prejudices. And that is why, for me, this explosion of this idea of objectivity became very important. And that informed everything that I taught at the National Law School. And that informed my students' understanding of the law itself. They began to realize that history is not objective, neither is law. And that is the reason why, when I taught, I introduced myself by stating that I am a South Indian Christian woman teaching history using the materialist tools for the interpretation of the past from a feminist perspective. I made absolutely clear who I was and how I was going to teach the course. I didn't pretend that what I was teaching is universal, it is objective, and therefore applicable irrespective of time and place. And that made my students then question everybody who taught, because law is taught from a liberal positivist perspective in our country. I am sure that most of you teach law from that perspective and think that you're teaching an objective, law. Why can't your courses deal with all the injustices that are there in society? Like when we teach intellectual property rights, why don't we teach intellectual property left? As Dr. Lawrence Liang has developed that perspective, right? Copyright left. Why are we talking about copyrights only? The moment you start asking these questions, that is when you realize that what you are teaching is within a limited perspective. And everything, all the theories that we address are all theories till they are proved wrong or till they are proved right. And as new information comes in, obviously the things that we hold dear, things that we consider to be important, can be completely transformed, will be completely transformed. I mean, imagine just the question of the history of the subcontinent, right? The history of the Indian subcontinent, when the imperialist historians began to write, and even the nationalists, began with the Vedic people, the people who composed the Vedas. There's absolutely no understanding about civilizations and peoples who had inhabited the subcontinent before the Aryan-speaking people migrated into the Indian subcontinent. It is only with the discovery of the Harappan sites that myth was exploded. But it is so deeply embedded in the practice of history and in all our minds that we can't think of a history of India other than as a Hindu Sanskritic history. We're just unable to imagine an India where Buddhism and Jainism were the predominant religions till as late as 1200 AD, which means just 600 years ago. It is only between 600 and 1200 AD, through the rise of the Nayanars and the Alvars in Tamil Nadu, and subsequently the Veerashaiva movement in Karnataka, that Vaishnavism and Shaivism became dominant religions. And the religious structures belonging to the Buddhists and the Jains were appropriated, either destroyed or converted into Shaivite and Vaishnavite temples. Now, if we don't understand this, then we fail to understand the complexities and the diversities and the differences in the practices, socio-cultural and religious, in the Indian subcontinent. And the reason I use the Indian subcontinent is, again, very consciously, because without that understanding, we begin to perpetuate several myths. This idea of an undivided India, When in the past was there an undivided India? The only time that a large portion of this Indian subcontinent was united was under colonial rule. That was British India. That is not undivided India. Because even then, it did not contain all of the regions that have today come to form the different countries in this region. Therefore, friends, it is important to look at these nuances of the past, and we will not be able to understand this unless you bring in a critical perspective. And that is where, for me, both the Marxist and the feminist perspectives enabled me to question everything of the past. Because it wasn't enough to know what happened in the past. For me, it was more important to understand why did it happen so? Why was the Varnashrama system created by the Brahmins? Even if it wasn't widely practiced, why did they come up with this theory of Varna Dharma? And this came as early as the Dharma Sutra 600 BC. Another question would be, why was it so necessary to control the sexuality of women? It wasn't enough for me to read the Manusmriti who says women do not deserve independence, or to say that women are essentially evil. The question is, why did he think so? What was the need for controlling women? How did the state come into existence? Why? Why did we need the state? When you look at the Vedic period, there were tribal polities which were administered to tribal assemblies, the Sabha, the Samiti, the Vidhata, the Gana. And how did they disappear and instead come into existence monarchy? Why did monarchy come into existence? How did it come into existence? The moment you start asking these questions, the why and the how, that is when you will see the transformation that took place in the past and continues to inform the way in which our society changes. Now, the reason that I told you that, history is not about the past, but about the present, is because when you look at what is it in the past, we have 5,000-year-old history in the subcontinent. Why do we pick to research into only particular things and not others? Why hasn't anyone seriously studied the history of conversion in the Indian subcontinent? Why are we always harping on the Harappan culture, the Harappan civilization? Why do we want to prove that they were Dravidians or they're Aryans, their language is Hindi or their language is, Tamil? That happened some 5,000 years ago. What is the relationship between that civilization and us today? So clearly there are political interests of today, identity interests of today, which inform what we study about the past. And the reason the feminist perspective becomes interesting is because feminism isn't about, male bashing. Feminism is trying to understand how and why patriarchy came into existence and why patriarchy needed the controlling of women's sexuality and their bodies and all their freedoms. Trying to understand why there is so much gender-based violence prevalent in our society. This is a problem that has been there since the Vedic period. And it is yet to disappear. We still have to talk about it because it's so widely prevalent in our society. The feminist perspective enables us to look at the law in terms of the impact of the law on women, on society, rather than merely looking at, all these numerous legislations that presumably have been enacted for the benefit of women. And this is why when you teach legal history, for example, it isn't enough that you look, it isn't even necessary to be looking at the Indian Councils Acts and the judicial reforms and the Charter Acts. Of course, they have their importance and their place. But to understand the current society and the current functioning of the legal system, it will make more sense to understand how and why did we get the kind of laws we have got during the colonial period, be it the Indian Penal Code, be it the Civil Procedure Code, the Indian Companies Act, the property law. All of these have their roots in the colonial period, and they continue to inform our understanding of crime, of property, of justice, of contracts. It is important to understand how those were from a particular class and gender perspective. Why till 2013 did rape mean merely penile penetration of the vagina? Why did not rape mean sexual assault of women? Because you're not looking at how the woman experiences that crime. But it was from a male perspective, because penile penetration alone could produce pregnant women. And one did not want to deal with pregnancy outside of marriage. And that is the reason why any other form of sexual assault was not a serious crime. It was not an offense even. It is only this that was treated as a serious offense. And so if you could not prove penile penetration, it wasn't a crime. I mean, can you imagine till 2012, we didn't think all those sexual offenses against children were crimes because they didn't seem to impact our society adversely. And we've been looking at socio-religious legislations, like the Sati Abolition Act or the Widow Remarriage Act, the Caste Disabilities Act, as all reforms which transform society for good. Without looking at, did they really transform the lives of women and those who were impacted by those legislations? So therefore, when I taught legal history, as a result of the promptings and proddings from alumni who went on to see the way in which this interdisciplinary approach to the study of law and the past enriched their own thinking, I began to look into why was the IPC introduced into India? What were the reasons for codification being imposed upon British India when codification did not take place in Britain? When you start asking these kind of questions is when you can actually have a meaningful and a rich curriculum, and at the same time, for anyone who enjoys teaching, also a very exciting time in teaching to law students the various courses that we specialize in and we begin to teach. I just stop here for a minute, and also in terms of understanding our time frame. How long is this session?
Up to 11:30, ma'am.
All right, thank you.
Yes, thank you.
Are there any questions, any comments, any thoughts that any of you have? I'd be happy to respond to any of them. I come from a teaching practice of an interactive class system and not a one-way lecture. So if there are questions, I'd be happy to respond to them. Because if you ask questions is when I know you've actually been listening to me. When you don't ask questions, I know that you just, said, okay, let her talk what she talks. What can a history professor have to teach, law teachers? We are also superior. So if you ask me questions, you give me proof of the fact that you've actually been listening to what I have been saying. So the floor is open for any questions, any comments. You don't have to agree with anything that I have said. These are my perspectives based on my readings and my experience of teaching history in a law university. So if there are any questions or thoughts or comments, I'd be happy to engage with it.
Ma'am, may I?
Yes, please, Mr. Hira.
Yes, ma'am. With respect to the restitution of conjugal rights under Section 9 of
Yeah.
the Hindu Marriage Act 1955,
Right.
you have mentioned that the Sarita case. In
Right.
Sarita versus Venkata Subbaya, the Andhra Pradesh High Court has struck down the provisions as null and void, since Sarita's argument is this is my body and I am having every right to decide who has to touch,
Right.
who has to sensitize, and whatever it may be.
Right.
But
Right.
then coming to the another case, Harminder Kaur Singh case, in this case, the Delhi High Court has given the different verdict, stating that the objective of Section 9 of the Hindu Marriage Act is only to sustain the institution of the marriage. As such, what was the dictum laid down by Sarita case has not been accepted by the Harminder Kaur case in Delhi High Court. As such, there was the difference of opinion. Hence, the third matter goes to the Supreme Court in the name of Sarojarani case.
Correct.
Where the Supreme Court has overruled Sarita's case and sustained the principles enshrined in the Harminder Singh case. But recently, ma'am, I heard that the case with respect to the constitutional validity of Section 9 is again being challenged before the Supreme Court of India, and the matter is pending before the Supreme Court for its decision. And when coming to the another aspects, ma'am, with respect to Section 375 of the Indian Penal Code, the exception to Section exception 2 to Section 375. below or above 15 years of age. So the rape which is committed by the man with his own wife who is above the age of 15 years is an exception, and it does not come within the purview of rape, which is defined under section 375.
Right.
This matter is also now, I think the day before yesterday, the argument gets over in the Supreme Court of India, and they have argued, ma'am, if we allow or if we say that the provision is unconstitutional, section 9 is unconstitutional, and the exception 2 to section 375 is also unconstitutional, whatever it is happening between the husband and wife in the four walls, do you think that there is a chances of misuse of the provisions by the women against male community, ma'am?
Okay. Firstly, every time we talk about protection of women's rights to their bodies and their lives, immediately is this fear that there'll be misuse. And as somebody who has practiced law and has lived in the society, we know that various laws are being misused. That hasn't stopped anybody from continuing to enact laws to protect, certain things. But the moment we talk about laws to protect women's bodies and women's space, immediately the fear that there'll be misuse of the law. Again, with no offense taken against you asking the question, I mean, that itself, shows how gender prejudiced we are. It's very important to recognize that. Why do we fear that, women will immediately, I mean, can you imagine a whole bunch of women are going out to court and saying, oh, my husband has committed rape on me, I want to file an FIR, right? Women aren't going to do that. If women were going to use their rights, we wouldn't have to even talk about women's rights in the 21st century. But both the cases that you talked about, right? One is, my concern, it's not about misuse, because my concern is I wish women would use the law that is there, which safeguards their rights, which gives them access to justice. But unfortunately, women don't, because women are not socially empowered. So the question of misuse doesn't even arise, because of the fact that women are still unequal to men in society. We only have formal equality, which is why I said we have a plethora of laws which protect women. How many women who are subjected to domestic violence have actually gone to court? Why wait till this decision, right? The Protection of Women from Domestic Violence Act deals with sexual violence in marriage as a domestic violence. How many women have filed cases under that provision of the PWDVA Act saying my husband is committing marital rape? This is, sexual violence against me and I want remedy. If women haven't used that provision of law, which is already there, this act has been there since 2005. How many women have used it? Marital rape was already criminalized in that act because you could file, a case against your husband for sexual violence. Right? How many women do that? So why are we afraid that the moment the court says, marital rape is, an offense under the IPC, immediately you're going to have, criminal cases filed. PWDVA is, largely a civil law, not so much a criminal proceeding. And yet, even under that, if women are not filing, complaints, how do we think women are going to file complaints in the context of, a criminal law? That is one point. So I don't see the possibilities of misuse of the law just because the court declares that, this provision of IPC is unconstitutional. Restitution of conjugal rights. I would say that is a horrible thing. How do you force a man and woman to come and live together if they no longer want to have a relationship with one another? And you're saying what? You're not even saying live together. You're saying have sexual relations. That is committing rape, whether on the man or the woman. You're forcing them to have sex. And keep in mind that restitution of conjugal rights is a colonial invention. It's not there in any of the customary laws or traditional law or even the dharmic law of the Brahmins. In the Shastras, it doesn't contain that. There is nothing like restitution of conjugal rights. It was invented by the British in the 19th century. And the first woman to fight against that was Rukmabai. Rukmabai, who had been married off as a young child to somebody who was not her equal intellectually, did not want to go on having attained physical maturity to live with him. She is this who challenged that. She said, imprison me, but I'm not going to go and live with him. So the court, of course, found her guilty, because her husband had filed for restitution of conjugal rights. And then she appealed to Queen Victoria, and therefore they brought the whole thing down and they acquitted her. But we still have that provision. And I'm sorry that the sensitive, forward-looking interpretation by Justice Chowdhury was not echoed by the Delhi High Court. But forget Delhi, that is okay. It comes from the Bimaru states. You don't expect too much of, progressive thinking in terms of women's rights. But for the Supreme Court to have, endorsed it, extremely problematic. Just look at the reasoning, right? It was not about Sarita arguing, this is my body, I have a right to it. Look at what Justice Chowdhury said in that. He's a man. Look at what he said. He said the consequences of restitution of conjugal rights will have to be borne by her alone. She will get pregnant. And that pregnancy is not a temporary consequence. Lifelong, she will have to deal with it, because that child or that children that will be produced as a result of that restitution of conjugal rights is going to change her body, her life, till the end of her days. That is why I venerate Justice Chowdhury. Whereas on the other hand, in that Harminder Kaur case, what did they say? You can't talk about right to equality and right to life within the context of marriage and family. What do you mean? You mean to say if I'm married, my husband has the right to take away my life and I can't fight against that? That shows you how patriarchal was a mindset which upheld that restitution of conjugal rights in Harminder Kaur and in Saroj Rani. On the other hand, you have a progressive, humane thinking on the part of Justice Chowdhury, because he looked at impact of the law. He's not simply upholding marriage and family because they're social institutions. Marriage and family have changed so much since they first came into being. You cannot preserve an old institution in a new context. Today, when we talk about marriage and family, we're talking about a diverse range of marriages and families. We had polyandrous marriages in this country, in this region. We did not perpetuate polyandrous marriages, but we are unlawfully promoting polyandrous marriages through the sex selection process that have been carried on in Punjab, Haryana, where today one brother goes and marries one poor young girl, poor, literally poor, economically poor, from Bihar or from Andhra or from Jharkhand or Chhattisgarh or the Malabar region, and she then becomes the sexual partner to all his brothers as well. But we have forbidden polyandrous marriages in law. We only talk about monogamous marriages, but the reality is there are polyandrous marriages. Right? So if we think about perpetuating institutions that are unjust, that do not conform with the constitutional values, then that reflects upon our prejudices and the fact that we do not want equality and justice. We want equality for ourselves. We want justice for ourselves as men, as upper caste men, as property men, but we most certainly do not want that for women and for the Dalits and other subordinate castes. That is the advantage of knowing history and looking at the law from a feminist perspective.
Thank you, ma'am. Any other questions?
Ms. Shanti Samanta has written that every law to some extent will be misused, but historically and socially discriminated sections will never get a remedy if we do not have any affirmative actions at all. We do have the dominating section saying SC/ST Act is being misused by SC/STs as well. And the reality is that how many crimes against atrocities against the scheduled castes and scheduled tribes are actually being investigated and prosecuted? How many complaints have been filed? Right? So these are but the moment we talk about any laws to protect the lives of the exploited, oppressed, marginalized sections in our society, immediately the first response that we get from the dominant sections is misuse of the law. I remember that when the Vishaka judgment came out in 1997, I was at a wedding of one of my former students, and his father, who was the CEO in some company in Bengal, he comes up to me, knowing that I, was advocating women's rights even then, came up to me and said, now if nobody will want to recruit women because, there will be all these false cases of sexual harassment. I said, Should you be sensitizing men to treating women with respect? Or should you stop recruiting women in the workplace simply because now women can file police complaints against sexual harassment in the workplace? It is as simple as that. Any other questions, comments, or responses to what I've said and to the discussion that we just had? Okay, if there are no questions, then let me just briefly talk about the need for interdisciplinarity as to why, law teachers and law students should be studying history, while they are studying, teaching, or doing research in law. There are various kinds of, perspectives on what should be legal history. And I don't agree with most of them because, history is not to be subordinated to law. Rather, history has to be studied side by side with law. And the tools of research, the tools of teaching that have been developed in a discipline that is so much older than the discipline of law in our country ought to be, embraced and brought into use in order to understand the richness of law itself from a better perspective, from a more meaningful perspective, if we want to ensure that law achieves the objective of delivering justice. We should not be teaching law merely in order to know the law. There should be an objective, and that objective should be that law has to serve the purpose of justice. There cannot be, a separation between the two things. Unfortunately, a lot of us oftentimes think that the two have no connection. Justice will be what is done in the courts, and our purpose is merely to teach the law. But no, unless we teach law from this perspective of ensuring justice, you just cannot bring about, justice through the courts. So when we look at the practice of law and, why we need to be looking at, the discipline of history in order to teach law, you have a Sri Lankan professor who said that we may completely fail to grasp the significance of a rule if we do not see it in its historical context. Now, for example, the other day when we were revising our curriculum and the property law curriculum, somebody talked about, how in law, 9/10 of possession, gives one a right. But nobody understands why did possession give anybody right over, immovable property. Now that comes from medieval England. The fact that in medieval England, ownership of land was limited to a few, because all land belonged to the king. The king then made grants of land to the feudal lords, the barons. The barons in turn made grants of land to their subordinates, the various knights and other local chiefs. And therefore, people who got these grants of land would not have any titles to the land, and they obviously would not have documents which gives them ownership of the land. Which is why if you were in possession of that land for a certain number of generations, it gave you right to that land. Now, unless you understand something like that, you may not be able to think about changing that. Because today, no longer does the state own all the land. We have clear titles to the land that we are in possession of, ownership of. Now, unless you understand this background, and similarly to several other rules that are there, in fact, for all of us who are practicing common law, the several rules of equity that are in practice cannot be understood fairly and properly unless we have this understanding of when did this rule originate. And most of the rules of equity, which also govern many of the rules relating to trust, all originated in medieval England because of the fact that the common law did not have remedies to all the new problems that were cropping up in English society at that time. You have the chancellors who were members of the church. They were people who held actual positions in the church, who were the chancellors, And who provided these solutions to the problems that were cropping up in the society after the medieval times? And therefore, why you have all those principles which say that equity differs according to the size of the foot of the chancellor, because every chancellor developed a new rule depending upon the context that was there during his times. Which is why Professor Veeramantri is saying that we may fail completely to grasp the significance of a rule if we do not see it in its historical context. The very Blackstone principle that you could beat a wife even with a cane, so long as it was not thicker than your thumb. Because wife beating was a common practice in modern England. Wife beating went out of practice only as, the rights of women began to evolve during the late 19th century. So you cannot be quoting, Blackstone and others to say, these eminent legal scholars have been saying these things. Similarly, Veeramantri goes on to say that even the practical legal reformer cannot address herself adequately to planning the law's future unless she knows its past. Which is why you cannot talk about legal reform unless you understand why is it like, today the government wants to completely replace the Indian Penal Code. But unless you understand why did the Indian Penal Code take the form it has done, and how has it been implemented since it came into existence in 1860, you cannot possibly create a better Indian Penal Code in the 21st century. You'll end up perpetuating the same wrongs and losing possibly the good points that are there in the Indian Penal Code. We've amended those provisions of the Indian Penal Code that have not been in keeping with the changes in our society. For example, Section 377. Because we've said you cannot criminalize consensual sex between two members of the same sex. But you can continue to criminalize sex between two members of the same sex so long as it is non-consensual. You cannot just criminalize, all forms of sex between consenting adults. And because the Indian Penal Code does not address the question of sexual offenses against children, today you have the 2012 Protection of Children from Sexual Offences Act. Because sexual harassment was not captured within the Indian Penal Code, you have the 2013 amendments to the Indian Penal Code, the amendments to Section 354, incorporating 354A, B, C, D, etc., in order to capture sexual harassment as a crime and not to be just seen as a civil, offense against someone, right? So unless you understand the historical context of all these legislations, you cannot bring about reform in law. You will only perpetuate the wrongs that are there, reinforcing the stereotypes that are there, while possibly getting rid of things that are important. Because the Indian Penal Code, remember, was not drafted in 1 month by one man. The Indian Penal Code, the drafting began in 1833. And from then on, it underwent several transformations before it was enacted as the Indian Penal Code in 1860. It is important to have that kind of understanding of the law and its past before you can indulge in reformation of the law. And it is not only the mere specific rules of law for which it is important that one looks into the past. Veeramantri says the very basic attitudes and the spirit of a legal system will be completely missed if you neglect the historical aspects of the legal system, which is why I talked about the colonial context in which all our laws and the very judicial system which we have today are rooted in. Because if you do not understand that colonial context, you will not be able to understand all this paraphernalia and this entire protocols, etc., which surround our legal system. And therefore, why Justice Sanjeev Banerjee said that the one thing he was sorry when he left the Madras High Court is that he could not completely get rid of the feudal system that prevailed in the Madras High Court. And I'm sure that the feudal system prevails in all our high courts and not just in the Madras High Court, because we are perpetuating the colonial legal system, the colonial judicial system. all this business of the Darwan standing out there with that mace and, he marching in front while, all these judges come out of the High Court and follow him. All of this is just so reminiscent of practices which existed 200 years ago. So on the one hand, we talk about, technology and the rapid movement with which it changes. And on the other hand, we are holding on to institutions and, characteristics which are gone in our society or should be gone from our society. Another point that he also addresses is that unless you understand the social, economic, and cultural history of a country and see how they contributed, to the spirit and content of the modern law, you will not be able to fully appreciate the impact of history on law. Why we have the kind of, even say the gender percentage, the gender ratio in our courts is also the product of the way in which the law and the legal system has developed. He says, even the rare jurist or judge who is able to rise above the currents of his times and to point magisterially to basic improvements is to a large extent conditioned in thought and action by his milieu. In other words, that even judges who rise above their circumstances, their caste background, etc., are able to do so only if they're conscious of where they come from. Otherwise, they're informed by those background. I mean, look at all the decisions that we have, that we consider as landmark cases. Look at the judges who delivered those judgments. Only then will you be able to understand why you have particular courts which bring about these socially transforming decisions and why in some other courts it's a perpetuation of the same thing. And it's only when judges are informed by the consciousness of their positions can you hope to see the changes. He says all people, lawyers and judges included, are the creatures of their times and circumstances. And the legal systems they evolve are not purely logical exercises, but practical compromises and suggestions prompted by contemporary events. Let's take the Geeta Hariharan case, which talks about the natural guardian being the father, and then comes the mother. And in that judgment, while they recognize the problem that that kind of a provision of law made, they still were reluctant to strike it down and say that it is unconstitutional. Till you start looking at the constitutional values as paramount and everything else which is in conflict with it as unconstitutional, therefore to be struck down, you cannot possibly bring about justice, liberty, equality in India's society. How does a woman who bears a fetus for 9 months not be the natural guardian? You're using the language, right? You're using a biological language. You're saying natural. When you say natural, what is more natural than a mother being the guardian of that baby she brings to existence than a father who she is married to? Right? As somebody said, somebody is your father only because your mother said that person is your father. Only she knows who is the father. And yet, such a man is made the natural guardian of the child to the cost of the mother who bears the child. And we have such unequal, unjust laws, and we'll continue to have them unless we bring into our understanding of the law this interdisciplinary approach, which looks at the unjustness of such provisions in the law. And that is the reason, one of the many reasons, why we need to have an interdisciplinary approach to look at the law from the perspective of the past, to use the tools that have been developed by those teaching the past and other disciplines if we want to bring about an understanding of the laws and the legal systems as we have them in the current circumstances. And that's the reason when we are talking about history for law students. And in our country, we have two courses currently that should be taught in the institutions. One, as per the Bar Council's own prescription, history course that takes into consideration the history and culture of India. And on the other hand, a history course that should deal with the legal history. Now, what should legal history be? Should legal history consist of the evolution of law in India? And can such an evolution of law be studied in isolation from the surrounding social, political, and especially economic circumstances? In other words, can law and legal events be studied without understanding the social context in which they come into existence and are being enforced and implemented? If you don't understand the society in which this law is to be implemented, how is it going to bring about any change? Which is why, like, oftentimes people now talk about how, Section 377 being declared unconstitutional has now brought about, right to marriage for the sexual minorities. Fact is, it isn't. Even the Nalsa judgment hasn't brought about equality for trans persons. Because our society is still rooted in the colonial prejudices against homosexuality, against trans persons. And therefore, I don't know if any of these people can now go before the registrar of marriages, and say, the two of us are now coming and giving our intention to get married. And 1 month's time from now, we'd like to get married. And that the registrar will say yes. And that's the reason we're saying how there is need for amending our laws relating to marriage if we want to actually give people belonging to the LGBTQI communities the right to marry. Because if you're not going to look at the social context, you cannot possibly bring about changes in the law which will actually bring about such transformation. And which is why you just have to go back to our constitution. Look at the Constituent Assembly debate surrounding Articles 15.3 and 15.4, right? On the one hand, you have the right to equality, the right against discrimination, and yet within that Article 15, you have Article 15.3 and Article 15.4. If you look at the Constituent Assembly debate surrounding it, what did they say? They said just because this Constituent Assembly proclaims a right to equality, centuries of practices of inequality will not end overnight. Centuries of discrimination against these marginalized communities will not end overnight. And therefore, unless you have Article 15.3 and Article 15.4, right to equality and right against discrimination will only remain a formal right. And as you know, it is because of the existence of Articles 15.3 and 15.4 that we've been able to enact laws, we've been able to enact policies that will actually pave the way towards actual equality for women and the marginalized social communities. That's the reason why we have so many policies of reservation, which have ensured that women have right to decision making in local bodies for now. This would not have been possible, and women wouldn't have an equal right to decision making at the local government level, at least, if it wasn't for Article 15.3. And Article 15.3 became possible because the Constituent Assembly, consisting of several lawyers, realized that if you do not understand the social context in which this constitution is going to be adopted, this constitution will remain a farce. And the same thing has to be the knowledge that will inform everyone who is practicing law in our country today. And that's the reason why it is important to study history and to include history in the curriculum of all the law universities. Because there are those who think that legal history has no place in a law school, as the business of the law schools is to train practicing lawyers. And such an argument, of course, comes from the thought process that the essential purpose of legal education is to prepare future lawyers and judges for their legal careers. And in fact, White states that it can be maintained that a law school can exist to offer its students a variety of intellectual experiences. But this is often a minority view. Another argument contends that our law school courses should have some practical or professional value in order to help produce competent practitioners. Further, another argument states that if law school subjects should have some practical or professional value, then legal history can properly be excluded or de-emphasized because it lacks such value. It lacks practical or professional value in both its content and its method of analysis. Now, those are the kind of arguments that are there against the incorporation of history in the curriculum of the study of law. And which is why there are institutions where history is not taught at all. And that is very unfortunate, because it means then you're looking at the law without an understanding of the social context in which law has come into existence and the social context in which law has to continue to function. You know, when people in society look at the law and the legal processes and they're frustrated, they cannot understand why there is so much of crimes against women and against the marginalized sections. When they say there are so many laws, it comes from the failure of the judges to understand the social context. Because the various things that they say in their judgments has oftentimes reinforced these gender stereotypes, these caste stereotypes, rather than breaking these gender barriers and creating a society in which there can be equality and equal access to justice for all sections of the society. Because we still are unable to understand and recognize women, Dalits, and other minorities as equal citizens of India. We look at all of them as beneficiaries of the law, as people who have special protection of the law, and not as people who have the right to equal protection of the law. Now, if you want me as a woman to be able to exercise my equality of right, equal protection, equal freedoms, and if you fail to understand that there is violence prevalent in society which prevents me from exercising my right to equality, my right to the various freedoms, then means that you do not even acknowledge that I, as a citizen of India, have this right to equality. That it is this existence of violence against women which prevents me from exercising my right to equality. And you have that ignorance because you're not looking at the social context, that a woman within the home has to deal with such violence. You know, when Mr. Hira talked about misuse of the right to be free from being violated by one's own husband in one's own bedroom, you have to realize that failure to protect me from my husband violating my body in my house prevents me from getting out of my house, prevents me from exercising my right to work. Because if I'm daily humiliated within my home, I begin to think that I'm not worthy of living a life of dignity. Because sexual violence is one of the worst ways we can function in order to violate the essential dignity of being a human being. You know, when a man says, I can have sex with you whenever I feel like, whether you are in the mood for it, whether you want to have sex with me or not, you're telling that woman, you're nothing more than a sexual object. And if you cannot recognize that, how it violates my fundamental right to life, then you fail to recognize the purpose of law and justice in society. And that is the reason why women's groups have been arguing for the right to live a life free from violence. And violence for women isn't out there in society. It's largely within our homes. Violence from our fathers who can beat us up when they feel like. Violence from our mothers who can slap us around because we want to go and have a relationship with someone outside. Violence from our brothers who think that the family honor is violated if we have a relationship from someone with someone who is not from the same caste or not approved by the family. All this violence happens within the home. And then we wonder, why are women not there in the public place? Why are women needing still to be protected from violence? Because I might be educated, I might have a job, but do I have control of that money that I'm earning? Am I able to decide what to do with that money? Or is my family deciding it? Be it my parents, be it my husband, be it my in-laws. And if I cannot decide what to do with that money, what is this freedom that we are talking about? What is this equality we are talking about? And trust me, friends, if you start looking at all the disciplines that you are teaching from a feminist perspective and using the historical approach, you will be able to see the problems with the things that you are teaching and how you are perpetuating patriarchy, how you are perpetuating caste inequality, how you are perpetuating class inequalities. And how, therefore, what you're teaching and what the Constitution says are two different things. And please keep in mind that we as students of law, teachers of law, as practitioners of law, have to adhere to only one set of values, and that is the constitutional values. Nothing else can supersede what is contained in the Constitution. The preamble to the Constitution tells you what is the value system that we ought to be perpetuating and, instilling in our students, in the society around us. I will stop there. And once again, I'm open for any questions, comments, or interactions of any kind.
Thank you, ma'am, for a mind-blowing speech. Any questions? Ma'am, one more information, ma'am.
Yeah.
Since I want to know, I'm asking. I'm not sure whether any case has been filed, but I have read in the newspaper. The husband is showing much abundance love on the wife. Hence, the wife has filed a divorce petition before the court stating that my husband is not fighting with me. Always he is showing abundance love. It is irritating. What is your opinion, ma'am?
It's a question of what is this abundant love? Is this abundant love possessiveness? I mean, not fighting is one thing, but also is a question of, what do we mean by this abundant love? Because oftentimes we presume that possessiveness is love. It isn't. That's the reason why I get offended when people say, you are the most important thing in my life. If you're looking at me as a thing, as an object, then you're not looking at me as a human being. And that is problematic for me. Similarly, if I can't bear to have you out of my sight, that is possessiveness. And that comes from insecurity of the man or woman who wants to have constant watch over that individual. And that is not love. Because as they say, if you truly love someone, you've got to give them wings to fly. The moment you're possessive, it isn't love at all. So for me, unless, I understand what is this abundant love, what is the nature of this abundant love, I can't really comment on it. I'd like to know what is this abundant love, in what way this abundant love is expressed. Then I will be able to say whether the woman is right or the man is right, and whether the woman has actually any grounds for filing for divorce.
Thank you, ma'am. Any other questions from the participants?
Good morning, ma'am. Good morning,
Yes.
everyone. Ma'am, there's one question I have regarding the discussing the class with the interdisciplinary approach. So, ma'am,
Right.
one of the practical problem which I find that when we discuss some legal provisions with the interdisciplinary approach, and there are certain subjects where it is required that interdisciplinary approach must be there. For example, the competition law. But we have, as a law teacher, we have a limitation of law knowledge in the other discipline. So when we discuss and when we say that on this particular issue, there's a debate, but we don't have a certain answer. So in the domain of law, at least we can say this is the law and this is a debate. But when we go and discuss to other discipline, we find very difficult to give a satisfactory answer to the student. And that leads to a lot of confusion rather than some sort of clarity in the mind of a student. So what should be done in that regard?
Okay. Firstly, of course, is that interdisciplinary approach to the teaching, the study of law is not restricted to any particular area of law. All the law courses should be taught from an interdisciplinary perspective. Okay, that's the first clarification. Constitutional law, labor law, company law, and of course, competition law, all of them, right? They all can be taught from an interdisciplinary perspective, should be taught from an interdisciplinary perspective if we have to, do justice. To address a specific problem that you raised, right? Yes. Now, for example, if I am teaching history and law, how do I bridge this gap? My ignorance of the law on the one hand, and my profuse knowledge of history on the other. One is, of course, for us to be self-informed, that we read all the latest decisions, discussions that are there from the other perspectives relating to that particular subject that we want to teach. So that is how I grew. So I had a PhD in history. I went on to acquire an LLB. But my understanding of this interdisciplinary approach to the study of law came from my own self-learning of law as well as feminism, and continuing, of course, to engage with history as a discipline, so that all the three informed the way I taught law as well as I taught history. Now, that is one way of doing it, that we learn and we keep growing in our knowledge so that, we become better informed about the debates that are there and therefore bring it into the classroom discussion. But an easier way is that we have colleagues who teach those disciplines in our institutions. So if you're teaching competition law, you have teachers who are teaching, business laws in our university. On the other hand, you also have the professor of economics who teaches this. You also have a professor of history. So you bring all of them together in order to do this in the classroom from what we used to practice in the National Law School, cooperative teaching. So you are teaching, competition law from the perspective of the law teacher. You have Dr. Felix, who will then step in to teach law, competition law from the perspective of the discipline of economics. And you could get Dr. Kumar to come and teach, the historical context of competition law. So that way you yourself do not have to be directly right now informed about these debates in competition law. You are doing it through the cooperative teaching process. So, like when constitutional law, for example, is to be taught in NLSIU, we will be getting Professor Vijay Kumar, in the course of this week. Professor Vijay Kumar used to teach just the bare text of the Constitution. Professor Devidas used to teach from a very analytical, critical perspective. So he would question the Constitution, he would question the interpretation by the judiciary. On the other hand, Professor Muller, the late Professor Muller, used to teach from the perspective of the judiciary. They would disagree, right? And Professor Devidas used to insist that Constitution has been interpreted completely wrongly, that what we have is a Constitution based on the presidential model and not the parliamentary model at all. Now, there were three different people, three different perspectives teaching the same thing, but it gave the students a rich understanding of that discipline of constitutional law. So you're absolutely right. When we are not ourselves well informed about these debates, it might create more confusion than clarity. But all you need to do is bring in the teacher who is engaging with those debates so that the student gets clarity about that particular area of law.
Thank you, ma'am. Thank you, Anand sir. Anybody else?
Any other questions or comments or clarifications? Okay, there's just a comment by Ms. Samantha in the chat box, which said not only possessiveness, just not letting a woman become independent is itself problematic. Which of course comes from the need to control women's freedom and women's right to be autonomous human beings, which is why neither women nor society has been able to acknowledge that woman is first a woman, a person. Then she becomes a sister, a daughter, a mother, a wife. But because we can't see a woman as an individual person, and therefore we do not think women have the right to independence, that women have right to autonomy of their bodies, which is why, from simple things like restitution of conjugal rights to, very complex policies like population control, right? We have sterilization, which is carried out in our country, and the people on whose bodies we have sterilization carried out is women's bodies more than male bodies. Though vasectomy is a simpler procedure compared to, tubectomy, we find that we do more tubectomies than vasectomies, because the right of a man to protect his sex and sexuality is, more greatly safeguarded. And women's bodies are merely seen as, these bodies which produce babies, and not as a woman having the right to control, which is why even all these debates about abortion that happens. That is the reason, again, Ms. Samantha, when you say all done in the name of love, is not about love at all. It is possessiveness arising from the insecurity of the man, who is afraid that if he allows the woman freedom, that she'll end up making choices which may not be the choices that he wants her to make. So that is why I said, this abundant love, we need to define what is love, because oftentimes when there is this acid throwing on women, when there is stabbing of women, you have the policeman say he loved her so much and therefore he did it. No, he didn't love her at all. It was possessiveness. Possessiveness is not love. Throwing acid, would you throw acid on something that you love? Would you throw it on your parents? Would you throw it on your children? You don't. Because when you love something, you do not cause it pain. When you love someone, you do not cause them pain. Possessiveness is not love. We need to be able to distinguish that. Unfortunately, we don't. We think possessiveness, oh, he loves me so much, he doesn't want to, let go of me. No, you love somebody, you let them, you give them freedom. Because if then they come back to you, then you know that they loved you and they're not with you simply because you have power over them. That is not love. Yeah, if there are no other comments, questions, or interactions, maybe then we can bring this session to an end. So there seemed to be some problem about accessing the feedback form. I hope that is sorted out. Dr. Felix has shared in the chat box. Please access it.
Felix, sir?
Yes, sir.
Yeah, he shared the link.
Yes, sir. Thank you very much, ma'am, for your deep knowledge on the interdisciplinary approach to teaching and study of law. Your words were full of enthusiasm, valuable knowledge, inspiring and thought-provoking. Once again, thank you, ma'am. Gratitude is the fairest blossom which springs from the soul. Every celebration is an experience. The external fades away and the internal remains and reverberation in the most depth of our hearts. We are reminded that events like this, one are the landmarks on the journey of life and reminders of God's fidelity all through. As we come to end of our inaugural session, I request Dr. Thomas Felix, Assistant Professor of Commerce, Tamil Nadu National University, Tiruchirappalli, to propose the vote of thanks. Over to you, sir.
Thank you, sir. A graceful and warm morning to our most valued chief guest, Professor Dr. V.S. Elizabeth, Vice Chancellor TNNLU, most beloved Registrar Ms. K.R. Leela, dear faculties of TNNLU, admin staff, IT staffs, and dear participants. It's my privilege to have been asked to propose a vote of thanks on this occasion. I, on behalf of the FIP committee, and the entire fraternity of the university. First of all, I extend my most sincere thanks to the Vice Chancellor, TNLU, for making this event happen. On behalf of, I extend a very heartfelt vote of thanks to the chief guest who enlightened us through her talk on need of interdisciplinary approach to teaching and study of law. I would like to extend my sincere thanks to admin staff and office staff who spare time from their busy schedule to grace the occasion. I thank all the participants for sharing with us your opinion and finding the present time. Thank you. Thank you all.
Thank you, sir. Now I request all the participants to rise for the national anthem. So the sessions comes to an end. I request all the participants to join the technical session sharply at 11:40, since the event will start by 11:45 a.m. The separate links have been sent to all the registered participants. Kindly go to the browser and join in the session. Thank you all. Thank you, ma'am.
Thank you, Prof.
Thank you. Thank you very much.
Thank you.
Thank you, sir.
Peter, sir.
Sir,
Sendil,
this is
sir?
Sendil, sir.
Sendil, sir, please stop recording, sir. Then you could end the session. Then we will start the second session, sir.
Okay, second session is started with Peter, sir. He has started parallelly in the system, sir.
Okay, 11:40. Then we could stop recording, sir.
Yes, sir. Thank you, sir.
Yes, sir. Thank you, sir. Thank you.